Today, we're talking about aggravated assault and specifically the defenses that are most often applicable in aggravated assault cases. As a quick refresher, let's remember, aggravated assault is the regular misdemeanor assault plus an aggravating factor. So, most assault cases are misdemeanors. They're low-level misdemeanors or class 1 misdemeanors, and they occur in one of three ways. One, person A causes an injury to person B. So there is an actual contact and there's an actual injury. The second way you get it is if person A puts person B in reasonable apprehension of imminent harmful contact. So that means that person A is basically scaring person B, and person B reasonably believes that they're going to be harmed. You can be charged with assault for that, even though there's no contact. And the third way you get it is when person A touches person B and there's some sort of offensive contact, or that contact is meant to injure or to provoke that person, but there may not be an actual substantial injury. There may not be any injury at all. It's just a touch. So those are the three ways that you get assault. Then that regular assault can be aggravated. So it can turn into a felony if something happens. So let's say, for example, A has some injury to B, there's contact and A injures B, but that injury is very substantial. So B has some very serious injuries, it's going to aggravate it. Or if B happens to be a police officer, that's going to aggravate it because police officers are a protected class. Those are the different ways that it's aggravated. So when we start talking about defenses, we want to defend against the aggravators, but we also want to defend against the underlying assault itself. So how do we do that? The first way that you do that is by showing that A was not the cause of the assault to B. So A did not actually cause any injury. A was not responsible for the touch. A didn't actually put B in any reasonable apprehension of any harmful imminent contact. The way that you do that is by showing that something else was responsible for that. So A didn't do it, C did it. C was the one who actually caused the injury. There was a big scuffle. The police just happened to charge A because A was in the wrong place at the wrong time, but A wasn't responsible for it. C actually did it, or C bumped into A who bumped into B. So there's a chain there that happens, and you can show that A wasn't the cause of it. If A didn't cause the injury or A didn't cause the touch, then A can't be legally held responsible for it. So you want to attack causation. The way that this happens a lot also is B may be responsible for their own injuries. B may be have been drinking too much, or been on drugs, or have had a mental breakdown, or slipped and fell. Something happened and B caused their own injuries, but B wants to blame A because B is vindictive, or B had a bad relationship with A, or any number of reasons why. But B was responsible for the injuries, and so we can't pin that back on A. It's called causation, and it's very important in a criminal case. You want to make sure that you start defending against that. If there's any way to create doubt about how B sustained their injuries or B's situation in general, you want to make sure that you're looking into that and doing your investigation thoroughly there. The next way that we can do this is by focusing on what's called self-defense. So let's say, for example, A and B get into an argument. A's being pretty reserved. B has a mental breakdown. B gets very upset. B is somebody who snaps, and B starts to attack A. A maybe be bigger or stronger, and by responding to the physicality of B, B gets injured. So it's self-defense because A was not the initial aggressor. A didn't start the fight. A didn't do anything to instigate the fight, but A was just responding back to B's provocations, and so it's called self-defense. It's a defense that you can use if you're being charged with assault or aggravated assault. We see this a lot in situations involving a man and a woman. Unfortunately, in our society and our culture, if there's an altercation between a man and a woman, in my experience and our law firm's experience, most of the time the male is going to be the one arrested and charged. It's just how it works. When the police show up, if there's any dispute at all, the male is almost always arrested. The female is almost always deemed to be the victim. And so this can happen when, even if B, the victim, is the initial aggressor and A responds back to that individual, may cause injury, may cause a situation where it escalates into aggravated assault, but that doesn't mean that the self-defense argument goes out the window. Another defense is to make the argument that in a certain situation in assault when a person is placed in apprehension of imminent harmful contact. So there may not be any physical contact between two people, but the person who is claimed to be in fear, so let's say be in this situation, it was unreasonable of them to be fearful. This is called a reasonable person standard. You can't be afraid of anything. You have to be afraid of what is reasonable. And so if you can make the argument that there was no conduct by A that should have reasonably put B in a position of fear, of being afraid of any harmful imminent contact, then that element of the underlying assault is not met, and the aggravators aren't going to be applicable. They have to prove the underlying assault first before they can move up to the aggravators. So here we're just simply attacking the underlying assault. Also, you can be charged with aggravated assault. A lot of the aggravators are when there is a protected class. So in other videos I talk about that. But police officers, prosecutors, health practitioners, firefighters, doctors, teachers, all of these people are in protected classes. And so if there's an assault that occurs against one of these individuals, it's going to be aggravated. The way that you can get around this is you have to make the argument that the person who is alleged to have committed the assault didn't know about that person's status. They didn't know that they were a police officer. They didn't know that they were a prosecutor. And there's no evidence to show that that person who is a police officer or firefighter or anybody in those classes was acting in their official duties, acting in their official capacity, and that the assault was not related to their duties whatsoever. That would attack the aggravator there. And so these are the kind of the general ways that you want to attack any of the assault charges. You do this by going through a very fact-intensive analysis. What do we do in these cases? How do we gather evidence to make those arguments? Well, we look for these things, generally speaking. We want witness statements. So who was around? This happened at a bar. We want to make sure that we can get names of people who were around, get their statements, schedule them for interviews so we can see what their opinion was. It may go to causation. It may show that if there was an injury that happened to a police officer, that this was a big commotion. We had no idea that the officer was acting in their official capacity or that they were even an officer. So it's attacking the knowledge about whether that person was in the protected class or not. We want to gather statements. We want to piece together the whole thing because a lot of these things happen very quickly and they're hard to make a determination of what actually happened without further investigation. Same with neighbors or people who are around in apartments next door. We want to get their statements. We want 911 calls for the same purpose. We want to see what happened on the 911 call. We can begin piecing that part together. We want to interview everybody who's involved, all the police officers, any of the medical professionals, anybody except the victim we can interview. It's part of the discovery process. Surveillance cameras, body camera footage, dash cam footage, jail footage. We want to look at statements. We want to see what other people saw, if anybody was recording any of this stuff on cell phones and this stuff was impounded. We have a right to get it. We have a right to review it. It's an important part of an assault case. Same with medical reports. So a lot of these assault cases will occur with serious injuries, or there'll be some red marks on somebody's neck, or somebody will be in the hospital. We want to see what the doctors have to say about that. What caused the injury? Is there an alternative explanation for it? Does it match the police report? Does it match the elements of the assault case? And we want expert witnesses to be involved. So there may be an alternative explanation for a lot of this stuff. We may be able to reconstruct what actually happened inside an apartment or inside a house and show that this was not caused by our client. This was caused by the person themselves from slipping, from falling, or from doing something on their own that caused their own injuries. So as you can see, this is just a very topical, basic explanation of some of the defenses that are available in aggravated assault cases. If you've been charged with aggravated assault, want to speak with our office, give us a call. We offer free case evaluations, and we look forward to speaking with you soon. Thanks for watching.